Okay. Good afternoon, everybody, and welcome to this discussion on defamation, disinformation, slaps, and democracy, how defamation law can both threaten and protect public discourse. And my name is Kate O'Regan. I'm the director of the Bonavera Institute of Human Rights here in Oxford, and I'm delighted today that we're joined by a really eminent panel of people to talk about these questions. I'm going to give them each a brief introduction, but for most of you who have found your way here, you've seen their bio, so you don't need to have them repeated. So firstly, Gavin Phillipson is a professor at the University of Bristol and a visiting researcher here at the Bonavera Institute. Jake Rowbottom is Fellow of University College, Oxford, and Professor in the Law Faculty here in Oxford. James Weinstein is Dan Cracchiolo Chair in Constitutional Law at Arizona State University and a visiting researcher here at the Bonavera Institute. It's got the common theme. Satyajit Sana, practicing law in Delhi, India, who's with us online with a particular interest in freedom of speech and a former research visitor at the Bonavera Institute. And finally, Ronelle, it's clearly time you came to be a visitor at the Bonavera Institute. You are the Lee E. Teitelbaum Professor of Law at S.J. Quinney Law School at the University of Utah. So thanks to all of you for joining us. Just to fill people who are both here and online in, the format we're going to follow is that each of our panel members are going to speak for 3 minutes on the themes, and then we're going to pursue a series of questions which both panel members and other members of the audience, both in person and online, are welcome to comment on or respond to. We are recording, so for those of you who don't want to be recorded, your voice recorded, if you want to put it into the chat, please go ahead, and I suppose we could resort to pieces of paper here in the room. But other than that, we will be recording because there is quite a lot of interest in this conversation. So we'll start off just going by first name alphabetically and ask Gavin to give us his 3 minutes.
Thank you very much, Kate. Well, I thought it'd be helpful to start by comparing the United States New York Times and Sullivan standard, which is applied where public figures bring defamation cases, with the approach that I think is broadly found in liberal democracies across the Commonwealth and endorsed by the European Court of Human Rights. And I'd summarise that consensus as being that defamatory content should be protected where it forms part of responsible journalism or communication on a matter of public interest. So the European Court of Human Rights insists that to gain the protection afforded by the Article 10 free speech right, even in cases of public controversy involving major political figures, media bodies must have made reasonable attempts to verify allegations. The law thus aims at least to provide a strong incentive to ethical and rigorous journalistic practice, especially fact-checking. So in contrast, Sullivan will protect even very serious allegations made with no real attempt at verification, provided only that the claimant is a public figure, an increasingly broad and amorphous concept, and that the defendant honestly believed the allegations to be true, or did not act with reckless disregard for their truth. Now, subject to what Ronelle will tell us about what we can learn from the Fox, Dominion, and Alex Jones Sandy Hook cases, this seems to mean that even appalling lies about public figures can be told with something close to impunity, provided honest, that is, subjective belief in them by the speaker can be demonstrated. But I'm keen to hear more today about where the First Amendment is with that today. So to me, the key question for us today is which standard better serves democracy? My concern with the US approach is you have to put Sullivan together with two other US factors: a highly partisan broadcast media with no regulatory requirements for accuracy or balance, and the Communications Decency Act Section 230, which provides a complete liability shield for online platforms for the content they carry, even once they have full knowledge that it is unlawful. And these factors combined appear to me to help contribute to a US political discourse that, as we know, is rife with conspiracy theories, from the Obama birthers to the Hillary Clinton sex abuse, pizza parlor stories to the big lie re the 2020 election that Trump is still running on. And this political discourse and culture now seems to be posing a threat to US democracy itself, free speech threatening instead of supporting democracy. Finally, on the other side, we must ask, is the Commonwealth approach that I've mentioned too contextual, too uncertain, and hence still too chilling of investigative journalism that is bound sometimes to get things wrong? Or, as I suspect, is the problem, particularly with slaps, not the substance of the law, but the huge costs of defending libel action and the intimidatory impact of getting an aggressive lawyer's letter threatening proceedings, even if those proceedings have little or no chances of success. These are some of the things that I'm looking forward to us debating today. Thanks.
Great, thanks, Gavin, and very timely. Jake.
Great, thanks, Kate. Right, just to set the scene, 10 years ago, the law of libel here in England and Wales was reformed. And it was reformed in a way that was seeking to strike a different balance and make the law a little bit less claimant friendly. That was one of the big criticisms that was made prior to 2013. So what are the changes that were made? Well, they introduced a requirement for claimants to show that the defamatory statement caused serious harm to reputation. There was a reformulated public interest test. There's a single publication rule, and they get rid of jury trials as well. So some fairly major changes there. There have been significant change that they've had significant effects as well, because there are claims that brought now that fail that would have succeeded under the old law. So it has made a bit of a change. How much we can debate, but there's some change there. It's also made the law more complex as well, because you've got a lot of the old common law rules still in existence, and then what you've got are certain additional requirements superimposed on the old common law, so the requirement of showing serious harm. This means that there's a whole new set of factual findings for the judge to make. So that makes the law more complex, introduces certain procedural difficulties, and potentially increased costs as well. And on top of all of this, defamation law hasn't died yet in England and Wales. There were some predictions that it would following the Act, but there was probably, from what I understand, more defamation cases brought in the court still, as there are more so than there are privacy cases. So I still think it's one of the main causes of action that we see relating to communications in the media. Now, these reforms were enacted a decade ago. Reformers are still not happy. There is a big debate going on at the moment about an additional need to rebalance the law, in particular with claims about lawfare and slaps and so on. And a lot of the way that it's kept, quite often in the media, it's characterized as powerful individuals trying to silence critics and people who are investigating them. So it seems to have this chilling effect and a way of powerful people bullying others. Now, there's definitely an element to that. There are cases where that happens. There are cases where threats are made. But the trouble is with defamation is there's no single paradigm, because in addition to those sorts of cases that are definitely happening, you've also got your kind of standard case, which is about a social media spat. Someone makes an allegation on Twitter, then there's a claim that's made, and that finds its way into court. You've got traditional, newspaper alleges something, and then someone tries to set the record straight or vindicate their reputation. So you've got those traditional cases. Apparently they're declining, but they're still there. And then you've got other lines of cases where internal disputes within a political party, different factions in a spat with one another, those cases somehow find their way to court as well, and through the law of libel. So there's lots of different types of case at stake. And what the problem is that if we try to reform the law to deal with one, the bullying cases, that might have knock-on effects for those other cases that have greater merit. So that's one of the challenges we have in reform. And I think the problem, or the thing that we need to do, is diagnose the problem, see exactly what the cause of the problem is before we try and seek solutions. And I also think it's an interesting time to discuss this, because it seems here there is this additional wave of reform, but in the US, it seems there's another line of argument where there's arguments to revise Sullivan, and it feels maybe the US is going in a slightly different direction to the UK. So certainly interested to hear more. Thank you.
Thanks, Jake. Also very timely and a great intro to James.
Well, thank you, and thanks, Kate, for doing alphabetical by first name. It's very rare that I'm not last. I wouldn't have been last if it was
my name is Catherine with a C, so yeah, I think it's a good way to go.
Yes, and I'm almost always, as my father was going to change his name to A. Weinstein, early A. Weinstein, but anyhow, so I like to be in the middle here. So I'd like to focus on two questions posed by Gavin's extremely helpful framing questions. The first is whether there are signs of disenchantment with Sullivan in the US. The answer is yes. And here I will focus on Justice Gorsuch's dissent from denial of certiorari in Barisha versus Lawson, a recent case. And in this well-reasoned opinion, Gorsuch makes a good case that Sullivan's malice standard, far from promoting democratic self-governance, actually interferes with democracy, at least as applied to public figures, not just public officials. And I think that people use the word public figures to mean both public figures and public officials. I think there's a technical distinction, and it could become important. The second question that I'd like to discuss, time permitting, is the query in the email about the broader relationship between the First Amendment and disinformation. Here too, we find democracy on both sides of the equation. On the one hand, disinformation, especially about voting and the results of elections, as Gavin mentioned, can seriously undermine democracy. On the other hand, censorship of expression on matters of public concern, both by a government or private online platforms, also has the potential to interfere with democratic self-governance.
Great, thank you very much, James. Now we're going to call on another American lawyer, Renelle, who is online.
Hi, just wanted to unmute myself. Okay, can you hear me okay?
Yes, thank you.
Okay, thanks so much. I'm thrilled to be a part of the conversation and especially pleased to get to learn from these great minds today. I've been, you already see me frantically taking notes. For my part, I just wanted to quickly highlight two Trump era developments that I think are somewhat in tension. One, an outgrowth of the US political environment and the other of the US communications environment. And the tension that they create, I think, is really important and interesting here. First, from almost the very arrival of then candidate Donald Trump came his arguments in favor of, in his words, opening up libel law, a steady drumbeat of threats to push for doctrinal adjustment to make it easier for public officials like him to sue for defamation, and more significantly, to threaten to do so, kind of wielding the risk of suit as a cudgel that could be used to silence critics and shut down counter narratives. And because that steady pressure to eliminate the US constitutional rule of actual malice was often paired with additional rhetoric about the press being the enemy of the people and investigative journalism being fake news, the unwinding of Sullivan has come to be seen by a lot of folks in the scholarly space as being bound up in this wider, quite authoritarian effort to undercut democracy-serving arbiters of truth, academics, librarians, scientists, journalism, courts. And so that's a piece of it. And in the two co-partisans of Trump's on the Supreme Court, Justice Thomas and Justice Gorsuch, are the ones who have suggested that the court should have taken cases that would serve as vehicles for reconsideration of Sullivan. So far, it's just the two of them, but there is a lot of discussion about whether that sentiment may gain additional steam, especially in the conservative wing of the court. And this ties to the second of the trends, this communication landscape that's infected with this especially noxious rise of disinformation, including on topics for which a strong democracy just has to have trustworthy, transparent, accurate information, like public health and the integrity of elections. And here we see this rise of defamation law as an attempted pro-democracy tool with this crop of suits, postmasters and voters and election workers wrongly accused of fixing elections, and perhaps most prominently, this wave of cases brought by voting machine companies, damage to their reputation, but also alleging broader democracy harms of election denialism and panic mongering for profits. And the highest profile of those cases, Fox versus Dominion, the discovery and the settlement of it suggested to us in a really interesting way that the actual malice standard from Sullivan might actually be working quite well, at least in this sort of narrow space of democracy combating, preserving, cases of conspiracy theories invented and spouted for politics and financial gain. So part of what we need to think about is where Sullivan falls short, and also how the tensions of the two pieces of Sullivan work together. I think notably, nobody in any of those cases, Smartmatic, Dominion, the other voting machine cases, has been arguing that the unique US hurdle should be lowered, only that those cases are so egregious that it can be cleared. A number of us have moved to inquiries about what adjustments, if any, especially to the public figure component of the Sullivan doctrine, might be something that we need to be thinking about, but they didn't really come to the forefront in ways that we might have expected in those cases. These are the conversations that I see as sort of most seriously on deck amongst US defamation and free speech scholars, all happening in the shadow of this new aggressive Trump campaign and in the face of this tsunami of propagandistic conspiratorial disinformation that continues to give real pause to folks who would like a much stronger tool for battling viral disinformation, but are wary of the fuller retreat from Sullivan, given the ongoing threat of the weaponization of defamation law by Trump and his allies.
Excellent, a really fascinating debate going on in the United States. And now we're going to turn to Satyajit, who is in India and is a practitioner in Delhi, India, where these debates have also been intense and politically salient over the last couple of months. Satyajit, thanks for joining us.
Yes, thank you, Kate. And it's so good to be back at the Bonnevero in some form or the other. Just to add to this conversation and sort of slant it with sort of different perspectives, there are a couple of things I'd like to flag for the table. One is, of course, the EU's anti-SLAPP directive, which I think we might eventually come to in some form or another. And when I started looking at that directive a year ago, it was a sort of bold, fresh initiative. And over the course of the year, just a month and a half ago, essentially Brussels basically has significantly curtailed it. And the revised directive is something that we could, of course, I'm looking at with a sense of I don't want to say disappointment, but a sort of realistic assessment of how far a supranational law can go to actually in terms of commitments that countries are willing to make, states are willing to make on freedom of expression and defamation. The second perspective I think I'd really like to put out there is it's one thing to speak about curbs on freedom of expression in so to speak, functioning free democracies. And it's another to speak of them in authoritarian regimes. And it's yet another to speak of them in states which are in progressive forms of unfreedom, or which have landed somehow on the very gray line of illiberal democracy, which is where I would put a number of countries today, including India, with regard to things like this. And we can see where something as otherwise private and innocuous looking as defamation law can land a country, because as it stands, the most likely figurehead leader of opposition that India would have in the upcoming elections would currently be disqualified from standing for parliament because of a conviction, which is of course under appeal for essentially criminal defamation. So the ramifications and the way public space can be eaten up by something that was engineered to be a private remedy always is definitely something we can touch upon. And I think it would be really interesting to look at states where there's less of a consensus on what one can do than, say, a Strasbourg consensus or even a US standard.
Thanks very much, Satyajit. So that's a very interesting array of questions and thoughts that have been put on the table. And I'm going to just start with one or two questions for the panel. So Gavin has outlined the basic distinction between the US Sullivan approach, which requires that public figures broadly defined show actual malice on behalf of the person who defamed them in order to succeed in defamation cases, and what we might call the Commonwealth model, which broadly protects responsible journalism on a matter of public interest. And Kenyon and others have argued that this kind of Commonwealth model has spread. In other words, that Sullivan has not spread in the way that perhaps the approach adopted here in the UK in Reynolds and is now reproduced in Section 4 of the Defamation Act, but also in Longy in Australia, Grant versus Star in Canada. It's spread through the Commonwealth, and the idea is not that you use an actual malice standard. I think the first question is for you, Satyajit, and that is whether it's correct to say that the Indian Supreme Court has embraced one of these standards, either the Sullivan standard or what we might loosely call the Commonwealth standard, or whether you actually think the Supreme Court has vacillated in this regard.
I would say between definitely not a Sullivan standard. The Supreme Court has, of course, drawn inspiration for Sullivan and come halfway there, but it fails because public figures are not protected, are not in the same sense, are not thought of in the same sense as they are in Sullivan. in that sense. The Supreme Court has only gone so far, and I'm thinking of certain cases, as to say public servants. So that, of course, is a sovereign function, and that's broadly beyond the debate of beyond what we speak of. When it comes to, very powerful business persons, etc., that public figure standard has never actually been established. It's also not entirely up to the Indian Supreme Court. A lot of the jurisprudence of this is split at state courts, and state high courts tend to have different standards. Delhi, I would say, had a higher standard than Bombay, for example. Now, all of these are up for consideration. I actually will be in some of these matters this year, which are sort of set to reconsider what would be fit grounds for an injunction in a defamation case against a public figure. So it's an uncertain standard, and more importantly, the standard is, as Gavin said, highly contextual. And my difficulty with highly contextual situations is then you have to look at the judge. And then the next question that you will be forced to ask is your judiciary truly independent? Is it truly fair, free, and fearless? And at that point, I would have to say that I'd be very vexed to say that it is. I'd say enough of the Sullivan standard has been adopted that there is a vein of that kind of case law in India, but it's not an absolute standard. That absolute standard hews closer to the Commonwealth, but is tinged in different ways by laws that are, even date back to 1860. There are colonial era laws which have survived and continue to inform the way we look at free speech under a democratic constitution.
Thanks, Satyajit. That's interesting. And I just add for the conversation that the South African jurisprudence is definitely in the Reynolds mold, and has been really now since the late 1980s, and only 1990s, and just recently reaffirmed. So a defense to a publisher of reasonable publication in the circumstances where, for example, you can't establish that truth in the public benefit or something of that sort. So and highly relied upon. Turning then to the kind of issues that were raised, I think, by Ronelle. She talked about the huge settlements in defamation suits against Fox News when Dominion Voting Systems recovered $787 million from Fox in relation to its coverage of the 2020 election, in which the Fox program hosts and guests made false claims that Dominion's voting machines had been rigged to prevent Donald Trump from being elected president, and also against Alex Jones, the US radio host and conspiracy theorist, who was ordered to pay $4 million damages because of his false claims that the Sandy Hook shooting in Connecticut, and school shooting in Connecticut in 2012, was a ploy to push gun control. The question really is whether we can see these as the law of defamation actually being protective of democracy. Are these libel suits an effective way of tackling disinformation? And how do we feel about whether, recognizing that disinformation is indeed a problem in all our societies, I think across the board represented here, do we think that we can use defamation in this way? And I'm going to start perhaps with you, James.
Well, yes, I think it can be effective, as both those cases show. It's limited because you have to have an individual, some kind of individual or corporate, corporation interest. It would be very hard. There would be a lot of disinformation, be very destructive, that would not be susceptible to defamation. The actions, probably the basic, very destructive lie about Trump winning the election, being the legitimate president. And I mean, it has to, and this, Ronelle knows so much more about this than me, because it has to be of and concerning of some kind of plaintiff. And I think if a lot of the lies that are told about Trump being the legitimate president and the election being rigged, we probably couldn't, that the Dominion would not have had a cause of action. As I said, though, also on the other side, and again, this is defamation is not my real field of expertise, so Ronell and others could help out too. I was wondering, I think it was good that Fox News got busted the way it did. On the other hand, there is this notion of neutral reportage that's a little concerning, that I think that now it was rejected in that case, but I have a little bit of concern about broadcasters. I think should be able to cover even wild-eyed claims like the election was stolen. Now, I think what they did is that they endorsed, which pushed them over the line. But you can see how, again, you have democracy on both sides of that equation.
Thanks, James. I'm going to turn to you now, and perhaps one of the things in commenting on this you might talk a little bit about is the fact that the Fox case was a settlement, and actually how difficult this might have been if one actually ran a trial. And maybe one of the purposes of the settlement was to avoid having to give evidence.
Yeah, I think that's definitely true. That was true for both parties. And part of the complexity here is that juries are unpredictable beasts. And so each of the parties, I think, was sort of staring down the barrel. I mean, this was not just like an 11th hour settlement. It was like an 11th hour and 59th minute settlement. I mean, I was here poised, waiting for opening arguments to happen when the settlement ultimately came about. And I mean, I think that if it had moved forward to trial, there was a very significant chance that Dominion, the voting machine company, would have prevailed, and it would have prevailed under the incredibly defendant protective Sullivan standard. The discovery in that case was staggering in terms of the sort of trove of evidence of knowing falsity at least some parts of the decision-making process at Fox News. The pieces that I think would have been trickier were the pieces connecting the dots through the whole Fox corporate structure. The difficulty that you have, Sullivan requires not just that you show knowing falsity, but that you link up knowing falsity to the publication. That is, the decision to air these particular lies about this particular entity has to have been made by people with knowing falsity. So a piece of that trove of evidence was of folks in the wider corporate structure at Fox News saying things like, we know that the election isn't stolen, or these are conspiracy theories, broadly speaking to knowledge of falsity of election denialism more broadly, but not to the specific lies about this specific company that were told on these specific shows, or they were very specific comments about Dominion, but they were made by people whose shows, who were not affiliated with the show or the production of the particular host or presenter. So the connecting of the dots on those pieces might have been complicated. And I think this goes to the wider point that Jim was making and that others were alluding to about sort of how heavy a laboring oar we think that defamation law writ large can pull in sort of democracy preservation, and in particular, the countering of disinformation. It's a really fantastic tool in its own narrow space, or has the capacity to be one. But I have a lot of concern about the suggestion that it might be our primary tool, or heaven forbid, our sole tool for tackling these problems of widespread disinformation. You have to, as Jim said, have a reputation harmed on the other end of the disinformation to make it viable. And a huge percentage of the most damaging pieces of disinformation that are floating around in American democracy today are wrapped up, sometimes deliberately, in quite vague terms about elections being stolen and vaccines containing microchips, and they don't target any particular entity. They don't speak to any particular would-be plaintiff on the other end of it. And even then, when we do target those individual plaintiffs, you still have to have the resources and the energy. And the Smartmatic suit showed us, I mean, I think ultimately the reason that that case didn't move forward is that the settlement number got so high that a company like Smartmatic, it has to respond to its private equity shareholders at some point. Moving forward with the risk of trial isn't something that they can do. So we can only ask them to pull so much of a laboring oar on the democracy preservation front when they really are just a litigant in a civil suit. So I think all of those complexities are at stake, and the Sullivan piece of it complexifies it even further.
Great. So I'm getting lots of indications. Jake, then Gavin, is that right?
I wanted to specifically ask Ronelle about this.
Okay.
I was going to follow, yeah, similar sort of way. I mean, I would just say don't place too much weight on two cases. They're going to be sporadic examples. And you've not just got to have a reputation that's harmed, someone's got to be willing to fund the lawsuit. Typically, well, here, we're in a defamation case, the judge doesn't make a declaration of falsity. So it might not fully resolve the issue, even if you've got one side that wins. The judge doesn't make a clear statement that this is false. That might be the case as well if a case settles. It might not have clear terms with one side necessarily retracting or admitting something to be false. The other thing, I was interested in what you were saying, Ronelle, about how actual malice might be working when you're looking at some of these cases. I was wondering, that might work in those cases, but what about if you've got someone who genuinely believes a conspiracy theory? And I'm thinking then, will Sullivan offer protection and maybe do less to protect democracy that way? So that was just a thought I had. But, sorry, Gavin.
Gavin, do you want to?
Well, I had two questions for Ronelle. So one was, did Dominion clearly accept, either in the pleadings or it was just implicit in some way, that it accepted it was a public figure for the purposes of Sullivan? And if so, was that narrowly because it had been helping to run the election, which sort of put it in the shoes of the state, or was that just because there was a big public controversy and that made it a public figure? So that's the first question. The second was, so I can see why the actual malice test could be satisfied because there were these emails and so on showing that people had known that the allegations were false and had repeated and endorsed them anyway. But suppose you get someone like Carrie Lake, the failed candidate for governorship of Arizona, who still thinks to this day, seemingly, that she didn't lose and the election was rigged. If someone sincerely believes something that's highly unreasonable, it seems to me that they pass Sullivan. But I wonder if it's so manifestly false that despite their professed sincerity, can you get them on reckless disregard for the truth? Or does their sincere belief, however, batshit, protect them under Sullivan? That's the kind of thing I'm really interested in, because in a way that didn't apply in the Dominion case, because you had the discovery showed that they didn't believe it. But if you have Carrie Lake who puts hand on heart, and when you see her, she doesn't look mad. She says things, she has reasons. I mean, they're all discredited, but she doesn't look like a mad person ranting. Would Carrie Lake satisfy the Sullivan test, in other words?
So before you respond, Ronelle, we have another question.
No, I had a different point.
Different point. Okay, so Ronelle, we might come back to you on those, and particularly this question of how actual malice deals with completely misguided people.
Yeah, I think it's a really important question. On the precursor question about the public figure status in the Dominion case, Dominion made a very slight early argument against it, but knew, I think, starting out, I had early conversations with the lawyers in that case, and it was well understood. Because of a combination of the two factors that you described, that is the sort of central nature that they played in a public act of overseeing and monitoring an American election, but also because of the massive controversy that had emerged. I think the controversy standing alone is a little tricky because the idea is that the defendant ought not, through their lies, be able to catapult you into a controversy that thereby puts you in as a public figure subjected to a higher standard. But there was very little fight about it. It was understood that this was going to be a Sullivan case from the beginning. The wider question about, so Larissa Litsky and I, she's a sometimes co-author of mine and the new reporter for the Restatement of Torts on Defamation in the US that is thinking really seriously about the contours of American defamation law and for the generation to come. She and I have talked very seriously about, we have the early pieces of a law review article that we're tentatively calling The Delusional Defamer, which really does focus on this notion that we haven't really paid that much attention to, and that Sullivan sort of presupposed wouldn't be the case. Sullivan presupposes, if you read Sullivan and its progeny, it presupposes that people are rational, thoughtful contributors, that in the face of mountains of evidence, they won't walk around possessing information that is contrary to all observable objective fact. The case that might actually tee this up is the second voting machine company case. The Dominion case settled, but a second case, even larger, for $2.7 billion, brought by a company called Smartmatic, includes a claim against somebody named Mike Lindell. He's known in the US as the My Pillow guy. He is an advertiser of pillows, but also a spreader of conspiracy theories and a regular on Fox News and other right-wing media outlets, and seems to, by all accounts, fully believe to his core a number of easily provably false conspiracy theories that he has been spreading. I think, Gavin, that it is in fact the case that there is a fulsome enough body of literature on reckless disregard for the truth that sort of moving blindly ahead in the face of no evidence, in the face of, for example, in this case, dozens of courts across the country, including Trump-appointed judges, rejecting the election denialism as ungrounded and not viable, puts a person in a place where the court would presuppose reckless disregard for the truth requires a high degree of awareness of the probable falsity of the statement. But you're right that it's a space that is relatively under theorized, in part because we haven't had such flagrant examples of it make their way to the courts. And I do think this next wave of cases is going to require us to think about it carefully.
It's fascinating.
And there is something quite different, isn't there, between actual malice on the one hand and reckless disregard for the truth on the other. It's really making it very clear these are two different standards, and the actual malice one is much harder to establish because it really
because both things satisfy actual malice. It's just that knowing falsity is such an knowing falsity. I mean, the truth is that in my many years of teaching media law and First Amendment standards, I mean, I'd love to hear if Jim does it the same way. Like, for a long time, I think a lot of us said, you know, knowing falsity is going to be a really, that's not a thing that you're ever really going to be able to prove up, because what kind of an entity would have a sort of massive body of evidence internally saying to each other, right, this is flagrantly a lie and we're just going to move ahead with it anyway. And now it turns out that we're being served up with a set of fact patterns and discovery that actually provided that. The much more common path to successful Sullivan cases in the past has been the reckless disregard for the truth capacity. It's a very strict standard. It's the distance between it and what we would think of as journalistic negligence, or the kind of even the Commonwealth standard, right, is quite broad. It mere sloppy journalism or biased journalism or failure to carefully fact check or even reliance on an unreliable source wouldn't get you across the threshold for reckless disregard for the truth. The reckless component is really carrying a lot of weight there. But if it can be demonstrated that there was a high degree of awareness of a sort of subjective awareness of the probable falsity of the claim, that will suffice for actual malice. It'll be treated as the functional equivalent of having knowing falsity.
It's a technical matter. Under the Sullivan definition of actual malice, a knowing and a reckless disregard are subsets of, they're not separate of that.
Yes, two paths to showing actual malice, which is a terrible name. I wish it wasn't. Actual malice is a terrible name for the standard. It means neither actual nor malice, but it's it's the standard that we have.
In other jurisdictions, there may be a separation between reckless disregard and knowing falsity, but under they are both
joined together.
And
yeah.
Sullivan.
What was the value of that second voting claim, the second voting machines claim, you said how much they were suing for. Can you just want to make sure I caught that right?
2.7 billion with a B. It's almost twice the damages sought in the Dominion case. And one of the reasons that I think it's going to be so interesting, Dominion was actually, I think the newsworthiness claims in Dominion and in some respects, the neutral reportage claims that Jim was talking about in Dominion were, if anything, stronger. Smartmatic is a voting machine company that was only used in one county in the entire country during the 2020 election. Dominion was in much broader use and in some states that were important key states in the election. Smartmatic was only used in a single county. It was LA County, so it was pretty clear how that vote was coming out in any event. And it has much more of a David and Goliath feel to it than even the Dominion case has. It was sort of plucked from obscurity and then put into prominence by Fox News. I would sort of thought of itself as being on the rise for being an important technology that would be advancing democracy, and then was thrust into infamy by the vilifications that happened on Fox. So I think it will be particularly interesting to watch it play out, especially because now they can tap into all of this discovery that happened in the Dominion case. One of the main lies that Smartmatic says was told about it was the lie that it was affiliated with Dominion, that the two were in cahoots, that one owned the other, that they were jointly created in Venezuela to rig elections for Hugo Chavez and so forth. So the concentric circles, the Venn diagram of the discovery in the two cases is overlapping.
Thanks, Ronelle. Jake, do you have a question?
Just really quickly, what's the basis of the valuation? Is this business losses that they've suffered, or are these just general damages for injury to reputation?
It's both. And also in both Dominion and Smartmatic, there were security concerns, threats and harm made towards shareholders, people who were key players in Smartmatic. Mobs of angry people came for them. The valuation was actually a major sticking point in Dominion. There were lots of folks who suggested that Dominion was never going to be able to get sort of to its number, to anything close to its number in terms of being able to prove it up as compensatory. But it was, I think, probably meant to lay down a marker for a jury that was upset about flagrant lies, to also add on punitives and to give them a range for thinking about it. And my guess is the same is true in Smartmatic.
We complain about the level of damages and costs here, and we're never going to see anything like that. Is that out on a limb?
Brilliant, with a B. That would, I mean, part of it is the question of how to make it sting for the key parties who are incentivized. The undercurrent of the fact pattern. I mean, Dominion and Smartmatic both have the pleadings. Like a nerd, I have read sort of all 2,000 pages of the pleadings here, and the discovery. And the narrative arc is entirely rooted in a notion that Fox made a conscious decision, a conscious corporate decision to tell this lie, to lean into this lie, essentially seeing Trump supporters gravitating to other outlets in the right-wing media ecosystem that were more willing to entertain this election denialism, and that they made a choice for ratings and profit to win back those viewers. And so a piece of what both dollar figures are meant to sort of capture is the notion that unless you make the dollar hurt Rupert Murdoch and Fox News, they will continue to be incentivized to engage in this behavior. That is, of course, not compensatory. That's, of course, like living in a punitive space. But my guess is that's what both voting companies were sort of teeing themselves up to do.
Thanks, Ronelle. And I think we should come back to this question of general damages and potentially punitive damages in a moment. But I know that Gehanna's had a question.
But I'm also aware of the fact that my question might take the conversation in a different direction. No, I just want to pick up on something that Jim said earlier about the difficulty where there's no clear plaintiff. And I wanted to also maybe reflect on the fact that there could be difficulties in terms of a clear perpetrator or defendant in lots of contexts where disinformation and defamatory content can threaten democracy. And in a highly sort of anonymized environment in which you would get a lot of disinformation, and I think QAnon kind of comes to mind, you wouldn't find defamation laws as useful tools to deal with that. And the other sort of question I had is, how do we deal with a situation where the purveyor of disinformation and defamatory content enjoys a sort of political or even legal immunity? And an example comes to mind from Sri Lanka, where in the midst of people's protests and sort of struggle last year, the presidential secretariat issued a statement describing protesters as fascists, extremists, terrorists, and also used the term Arab Spring to mischievously evoke, a sense of Islamophobia that was already prevalent in society. And in that kind of situation, there, I would say there is defamatory content there, particularly in terms of how you describe protest leaders, but the ability to actually use defamation law to push back is very limited because of the nature of the perpetrator or the defendant.
That's a really good insight. A lot of the people that you even could find, the people who are doing these conspiracy theory online, they're going to be judgment proof, or you're going to get their $4.83 from their bank account, and also public officials often have immunity. The president of the United States has an absolute privilege against tort suit for torts committed within his or her, someday, I hope, official duties. Now, the line, we're going to test them on this about the official duties. So I have that about right.
Yes, and we are actually in the midst of testing that line. There is a defamation suit currently pending against Donald Trump from E. Jean Carroll, who was successful against him in one claim for sexual assault, a tort suit for sexual assault and defamation. But that the defamatory statements in the case that she just prevailed in were statements that were made after he left office. But she has an earlier suit that earlier in time, the fact pattern, but later in time coming to the court. Carroll won, that is still tied up in the courts on this question because the defamatory content came out of Trump's mouth in response to reporters at a press conference in 2019 while he was sitting president. And the courts are having to tussle with this dividing line between whether he was acting in his individual capacity when he veered off into this defamatory rant about an individual in his private life, or whether because he was standing at a podium answering responses and tweeting as president enjoys that immunity under the Westfall Act. And so I think that the question is well founded and an important one, and I think we may well be testing the boundaries of it in significant ways in the coming months in the US.
So there's a question online, which I'd be just interested if the panel would like to respond to, and that is whether disinformation isn't a kind of major driver of populism, and that when you enter into a settlement of this sort, because you're not getting to a judgment, because you haven't had the exchange of, the kind of the, as it were, the performative element of a court and hearing the evidence and seeing it, that actually that further delegitimizes the institutions of a democratic government. And just wondered how people feel about that these big settlements could be seen as deeply illegitimate.
Well, I'd just say the counter argument is that it's the discovery and then the coverage of the discovery that I think has had the most impact in showing to the public that Fox, key people at Fox knew that what they were saying or the story they were covering was false. And it seems to me that's the most important thing that came out of it, more than the damages, which obviously is great for Dominion, but the damages themselves don't help the public. But it also shows Fox must have thought there was at the very least a very good chance that they would lose. which I guess also has significance. But of course, yeah, it's not the same as a judgment.
It's a very good question. I think it really depends on the case. Sometimes like this, you get your bang, and I actually think that judgment is performative. It's also, I mean, that settlement, that amount of that settlement. But sometimes settlements are used to sweep things under the rug, and so settlements can sometimes be, as the person online asked, can be not ways to help fight disinformation. It really depends on the context.
Yes, and we should note, I mean, that ties into the wider point that we were making before. The US public is entirely at the mercy of the decision-making within Dominion Voting Machines Company about the timing of that settlement. They cared a lot, really, I think, wanted to make this case a referendum on the wider question of disinformation and election denialism. And so presumably, right, once that body of evidence was gathered in discovery, the Fox lawyers came forward with some fairly high numbers to try, because you would be incentivized, of course, to settle before the motions for summary judgment, before all of the sort of trove of information about what you knew and how you spoke of Trump and how you spoke of your own viewers, right? You would want to settle before any of that became public, and Dominion chose not to. It forced it to move forward to the motions for summary judgment. And we got a motion for summary judgment. There was, in fact, an actual order from a court, a motion for summary judgment that used capital letters that said it is crystal clear in all capital letters that this was false, right? That the statements that were made about these voting machine companies, this election denialism, was untrue. There was motion for summary judgment that was accepted and granted. We were only moving forward on the questions of the connection within the corporate hierarchy, sort of who was responsible throughout Fox, and this question of actual malice. Those were the only pieces of the claim. The harm to reputation, the falsity, the publication at the show level, those were all resolved on a motion for summary judgment and got quite a lot of coverage in the US. And so I think that, that was only because Dominion did that for us, only because, right, sort of we're at the mercy of this private entity that forced Fox's hand and made it move forward to a place in which all of that became public, and we got the motion for summary judgment. So I think that the point is incredibly well taken, that we can't guarantee that mechanisms that sort of rise and fall on civil liability claims to individual plaintiffs are going to result in public serving outcomes, or that they're going to have the sort of corrective, cathartic results that we hope for and need in a disinformation environment in a democracy.
Yeah. Thanks, Ronelle. So, I mean, those are fascinating cases. Yes, Satya, did you want to come in there?
Just to, I think, follow on what Ronelle was saying, I think it could be that we are over-focusing on defamation as a specific thing here, because, for example, in the Dominion cases, defamation only serves as a crucible of truth. It could have been any kind of other, any kind of other process that would have led to that same outcome. And just what I'm drawing from that is, when we're looking at disinformation in democracies across the spectrum, it's equally important to look at, in terms of what actually comes to the aid of democracies. I'd say curbs on hate speech or law and order provisions would have a greater sort of symbiotic relationship with democracy as such than defamation. It seems more incidental to connect them.
I mean, somewhat relatedly, I mean, I have thought it's very interesting. It looks as if Dominion accepted that they would be, or that it was accepted that Dominion would be in a kind of in the Sullivan sort of environment. But we know that there are many public figures in the US who have been subjected to defamatory statements repeatedly over a period of time, which are equally false, and which you would have thought that they might actually sue on. And I'm wondering here what the intersection is in a kind of way between political strategy and the possibility of legal relief. And is it that, did we see the Dominion case because they were not political actors and were therefore able to not worry about what the fallout of a big claim would be? Whereas if you were, a candidate for president, for example, you might feel that actually you couldn't use, even if you could make the case on a Sullivan basis, you wouldn't do it because the political consequences would be so severe. And we haven't really talked about the intersection really between, the political realities and pressures and strategies and legal strategies. And I'd just be interested to know what people think about that. Yes.
I mean, I've been really interested in that and wanting to ask kind of the Americans here, sort of. So I remember seeing a kind of Trumpian preacher, kind of ranting QAnon style, accusing specific Hollywood celebrities and Democrat politicians of being part of the sex trafficking ring, which is obviously highly defamatory. I presume would easily pass. He couldn't show any reckless disregard for the truth could be made out. But evidently people feel completely free to say these things. So they must assume either someone like Tom Hanks or or Hillary Clinton just won't sue for exactly as Kate said, for political reasons, or what? I mean, there seems to be there's been this feeling of impunity for sort of a decade or more. The most outrageous and really damaging lies for democracy. So that pizza sex ring turned into QAnon, which is poisoning American democracy. And obviously some of it is just loons on Twitter and anonymous or Telegram or worse, so you can't sue them. But identify with people like preachers in those enormous churches spewing out these lies. And I just wondered where the feeling of complete impunity comes from, to be able to say that about people who have got deep pockets, could sue you. If you knew the law, they would have at least a decent chance of surmounting the Sullivan test. So why is there no chilling effect?
No,
in that sense.
I know better than me, but I think if there really were deep pockets and they were making outrageous lies about, running pedophile rings in back of a pizza parlor, they might get sued and win. I think the bigger problem is a lot of these. So I said before, it's just a lot of these claims are coming out of the places where you're going to hard to identify, and they're not going to be.
There's a bit of a history in the UK where people have brought defamation claims, politicians have, and it's backfired. It can be a high-risk strategy because, also if you lose your claim, then, your career maybe, there's all of those sorts of problems as well. So I think it's a bit of the political strategy, and also you could be characterized as a bully. So all the stuff like anti-slack could then get used against you if you're a politician. But it is used here. It's used quite a lot. You see it like I said at the start about disputes on social media between political figures. There's a lot in the courts. There's also quite a lot of cases where people have been accused of, say, political finance scandals. They find their way into court as well. So maybe it's a cultural difference with the US where it's seen as part of the rules of the game. But here, there's a risk, but it happens. But in the US, I guess, though, Johnny Depp brought a claim. It was, he's not a politician, but it was high risk. So some people do.
His wife, my ex-wife.
Yeah. I mean, a piece of that, I actually, this ties back to when Jake was laying out his kind of taxonomy of the sets of different kinds of libel cases that we need to be able to make sure that defamation law can handle. The one that was most jarring to me was sort of politicians versus politicians. That's not a flavor that we really have in the US, right? People don't in part because of Sullivan, right? Everybody involved on both sides would be a public official or public figure. And the Sullivan standard it's hard. It's a very high hurdle to clear. And so lots of folks lose at summary judgment stage on actual malice, and lots of folks decide at the very outset not to bring them. But I think another piece of the explanation to the phenomenon that Gavin's describing is something we refer to in the US as the Streisand effect. Do you guys use that term there? A famous case involving Barbara Streisand, and she was suing. It wasn't a defamation case. I think it was a privacy case, but the suit itself drew so much attention to the harmful material. So no one knew about the harmful material in the run up to it, or the people who did know about it discounted it. This is a crazy person saying this about Tom Hanks, but right, like it isn't real. And there's something validating about Hanks bringing it to the courts and sort of putting it forward and making it headlines again. And so I do think that there's a PR calculation that gets made by a lot of folks who might well be able, if they really pressed, to get to a place in which they could back someone into a corner and demonstrate even if they could get to a place where they could demonstrate the level of fault, it isn't worth the candle, because the blowback, not from being seen as a bully, but from being seen as sort of having entertained it and legitimated it by putting it in the court system, I think is a real undercurrent to a lot of what drives defamation law decisions in the US.
Okay, so we're going to turn in a moment to talk about SLAP, but we've got a couple of two questions online from Ona Dell in Ireland. Nice that you've joined us. And the first is, how likely is it the Supreme Court is going to take a case to reconsider Sullivan? We talked about that a little bit at the outset. And how likely is it, do you think, that if it were to take the case, that actually there would be overruling or revision or something else for Sullivan? And Owen makes the same point that in Ireland there is an increasing number of politician versus politician cases, which is leading the idea of introducing anti-SLAP provisions, which will be the next substantive topic. So I'm actually going to just ask Jim and Ronald to talk very briefly in response to Owen's questions, if that's right.
Yeah, I don't think it's going to be imminent that they're going to take the case to overrule Sullivan. I think it's something that's percolating. I think that I want to recommend Gorsuch's dissent in Marisha versus Lawson, which he really makes the very good point that when Sullivan was decided, and you had these sort of legacy newspapers and 3 networks who were fact-checking and responsible journalists, it's one thing to have a little correction, but now when everybody is can be on have their blogs and online, that what's going to happen is that particularly as it was extended to public figure, particularly what's called the a limited public figure, getting involved in a controversy because maybe you're complained against someone who sexually abused you, then this makes you a public figure for that limited purpose. Gorsuch makes the very good point that this can become anti-democratic. Now, he does say, he talks about Sullivan, and I thought that the extension of Sullivan from public official to movie star was a mistake to begin with, because what does that have to do with democracy? What, Taylor Swift is, but as opposed to what the sheriff who was arresting Martin Luther King was doing. And then, as Gorsuch says, when it goes down to limited, just a vortex of public figures, and then you can get, the ordinary citizen can get chilled from speaking. And so it really can hurt democracy. So I think it's unfortunate, the polarization, that it's that this revision and others, it was saying that Gorsuch, I do think that I wish he had done it more explicitly, putting to one side the core Sullivan itself and more the vortex public figure. I think it'd be a good thing to revisit that and overrule. And I think it's really unfortunate. It's like so much in America now, it's blue team versus red team. And because Trump was against, mentioned this, all of a sudden, that the polarization is that we've now taken sides on this rather than being analytic and thinking about. But that's what happens with polarization. And I'm sorry, I wasn't recognizing this because I say this isn't really my field. But if that's going on in American defamation law, where academics are going, well, if Trump is for it, I'm gonna get it. That is really bad, and I'll leave it with that.
Thanks, Jim. Renal, do you want to supplement there, or?
I'll just give a sentence. I think that Gorsuch is wrong on the broader question of the usefulness of adjusting the Sullivan standard for tackling the wider problem of disinformation. He's right about the wider problem of disinformation and the threats to democracy, but I think for all the reasons that we just described, that not very many spreaders of viral disinformation are actually good targets to sue for defamation. And so the only ones that remain are the few remaining entities that we have in this country that are invested in fact checking and big performers of the press function who are countering disinformation, who probably rely upon and need the Sullivan standard in order to protect themselves against weaponized defamation suits of the sort that Sullivan was concerned about. But I think the point is absolutely correct on the sort of runaway train of, in particular, limited purpose public figures. That doctrine has emerged mostly in the lower courts. We have 4 cases total from the US Supreme Court on that doctrine, all concluding that somebody isn't a public figure. And the lower courts have just sort of developed this vast, broad doctrine of sweeping lots and lots of folks within that umbrella in ways that are making the Sullivan standard applicable in lots of circumstances that might not have been envisioned at the time of Sullivan, and certainly in the progeny of Sullivan. On the prediction front, if you'd asked me 5 or 6 years ago, will Sullivan ever be imperiled? I would have sworn up and down that the answer was no. In fact, people laughed when Trump said on the campaign trail, we should open up libel law. People laughed and said, right, like, you think that you can do that, but that is solid doctrine. That's foundational watershed First Amendment law. That's akin to Brown versus Board of Education in the United States. It's not movable. So the fact that we have 2 justices who are openly calling for its reconsideration, I think, is notable. There have been a number of cases that have a number of petitions for writ of certiorari that have been before the Supreme Court in the last 2 terms, where I've held my breath a little to see whether they're coming, and if they are, whether they're decent vehicles for thinking in nuanced ways, the way that Jim's talking about, right, the kind of real thinking that needs to happen in this space, or whether they look like more blunt instruments for simply unwinding the Sullivan protection. The court just said no to the most recent one that was there in conference in front of it last week. And so I don't think that there's a case immediately on deck. And I think separate and apart from this, this is a court that has been fairly active in reversing major precedent. It reversed Roe versus Wade. It's on its way to reversing lots of doctrine on the religion clause fronts. It's making a lot of fairly massive changes that are viewed by at least some in the American public as fairly aggressive and activist. And so I don't think it's looking to add to that mix anytime soon with Sullivan. So just as a institutional integrity, institutional legitimacy interest, it might have bigger things on its plate than this. But the risk is the odds are higher today than they were a couple of years ago, to be sure.
Thanks, Renal. I'd like now to turn completely away from the US for a moment. I want us to think about the slap suit problem, which is the other issue we wanted to deal with here. And this is really the question of well-heeled claimants bringing claims against less well-heeled defendants, very often activists, NGOs, smaller organizations, in a manner which is perceived to be seeking to silence critics of the well-heeled litigant, and how defamation law has played out in this regard. And the questions are, firstly, whether this is really an issue of substantive law, whether this is the principles of the law of defamation that are at play, or whether, in fact, this is a question of the fundamental inequality of arms that exist in so many of our societies around the being able to litigate civilly, and such that basically well-heeled litigants can identify people that they know that they're going to intimidate. There have been a particular problem, haven't they, in India, Satyajit? So maybe you might tell us a little bit about the situation in India and whether you do see this as a problem of substantive defamation law or whether you see it as a problem of inequality of arms.
I would say that less than as a problem of substantive defamation law, which is more or less, sensible at its core, especially when it comes to private figures in that sense. And we step back from the whole, democracy and the Sullivan question. When we do that, I think it's more a problem of abuse of process and the particular vicissitudes of procedural law. And I think that would be true in most parts of the world. The fact that basically the plaintiff, as the dominus litis, gets to pick a jurisdiction and knowingly make it basically very unfair for a defendant. And I would say the specific Indian peculiarity I would point to, and perhaps this, you could find echoes of this elsewhere, is that once somebody is sitting on an injunction, it's more or less very difficult to dislodge. So that's it's a bit of a first to the top thing, and once you have that, the entire sort of books, articles, broadcasts basically just fade from the public view until they are of no real use. And that can be just, very dangerous.
Clarify there, Satyajit, are you talking about prior restraint injunctions?
Prior restraint, or even just things that come out shortly after something is already entered the public domain.
Which then says you may not be published, you injuncted from speaking again on this point.
Speaking again on this point, if it's, for example, a book or something, then copies that are already that are not already in the market or in private hands to be pulled back, etc. So injunctions like that are, super dangerous, and they do exist. So the grant of those injunctions is, I would say, a bit of a peculiarity in India on the civil defamation side. We also continue to have criminal defamation, which is just a very interesting thing of its own. It has been constitutionally challenged, and that challenge was rejected by the Supreme Court in 2016.
Thanks, Satyajit. I'm just looking to see.
I was just saying, yeah,
yes.
and in English law, that does seem unusual because in English law, and I imagine there might be similar rules. I don't know in Canada, Australia, you can't have interim injunctions in defamation cases as long as the defendant's claim is going to plead justification or truth.
Yeah.
Barnard versus Perryman. So that is exactly what's up for debate before the Supreme Court this year. And that is that specific piece of law is something we've litigated back and forth in India over the last few years, and it's very much up for discussion. I'd have also said that was an article of faith for me, that rule was more or less inviolable, but it's more or less under assault.
So there's another issue, isn't there, in relation to slap suits, which I think is raising its head in courts around the world, and that is the entitlement of corporations to claim under defamation law. And particularly, and this brings us back to the conversation Jake was having earlier about general damages and compensatory damages. And here in the UK, as I understand it, there's been quite an approach in relation to the possibility of getting general damages as opposed to compensatory damages if you're a corporation.
So there's been a change in the law where you've got to show, if you're a company trading for profit, that you've either suffered loss or that you're likely to have some financial loss.
Serious financial loss.
That's right, yeah. So that's been the main kind of change that we've seen in the last decade.
Yes.
That's trying. But there aren't that many. Most
Jake,
of the cases.
can I ask a clarification? So you the litigant who brings it, let's just make it Smartmatic or Dominion and put it in the UK. At what stage, can you just sort of describe for me at what stage they would have to make that showing and what that showing would look like?
It was initially thought that it was going to be a preliminary issue, but because it's dependent on factual findings, it's something they deal with at full trial. So it's not used as a threshold for weeding out claims at an early stage. They tend to go to the trial there. So you could say it actually, no, there was a question.
You have to plead it, presumably. So you'd plead that you've lost.
Yeah, you have to get over the threshold of serious harm. But normally that doesn't get determined. What they'll determine is the meaning of the statement as a preliminary matter. And so in, publication, there are certain things, and was it defamatory? But then it's at the trial when they're looking at the full facts that they determine whether serious harm. So it's not like a gateway question. So
if there was, I was just thinking, you can go for strikeout, obviously, which is what defendants will try and do if they think the claim is without merit. I mean, that's costly, which is one of the reasons for having improved procedures, particularly around easy and quick strikeouts and lowering costs. Because a London lawyer told me that you can strike out an unmeritorious claim, but it'll cost you about £50,000 if you use a good libel lawyer, which obviously is out of reach for a lot of people.
But they're reluctant to strike it.
I suppose you could strike it out on the basis that there was nothing to indicate that there could be serious harm under Section 1, which would include no evidence of likelihood of serious financial
I imagine
loss.
it's quite a difficult question to
But it's hard
prove, actually.
get.
And how does it impact on your damages?
Well, in terms of the proof, just going to that point, the court is willing to make inferences, so you don't have to show concrete loss. They will make inferences if you can show that, because they're looking at likelihood as well, so they can get some testimony there. In terms of how it affects damages, I'm off the top of my head, I'm not. I mean, I guess you could still claim if there's consequent losses that you can show. I think you'd be able to claim for those, but I don't know if it's really. Off the top of my head, I don't know if it's made a difference in terms of damages.
So under the South African jurisdiction, which is slightly different because it's not the same law of libel, it's a Rome Dutch model, but this question of compensatory damages versus general damages, which are sort of damages for harm to reputation, privacy, those kind of things. There's recently been a major constitutional court decision in which the majority said that there will be circumstances in which general damages would not be available to a corporate if it looks as if it may have been an abusive process suit. So there's a strong dissent on that, but this whole question of slap suits, general damages was kind of rolled up together in that decision. And I do think that there is a sense in some cases, in cases that are alleged to be slap suits, that the well-heeled litigant is not that interested in actually recovering damages. They're really more interested in actually ensuring that the defendant feels chilled and not willing to be able to speak again.
One of the problems that you mentioned before, is it the substance of the law or is it the process? While I think a lot of the thinking now is it's more with the process, the two are linked. So going back to what you said on serious harm, what we talked about with serious harm, that's very fact dependent. The problem with the law here is that, well, it's not necessarily a problem, but it's very context sensitive. So it's hard to advise in advance, are you going to win? You don't have bright line rules there. Mm-hmm. So if you are going to try and defend a claim, there's risk involved, and that kind of exacerbates, that's where you're looking at the costs and thinking about it. So it's partly the substance of the law. But so I think there was a thick feeling that, things like the reverse burden of proof and all of that kind of stuff were factors that meant the law had a chilling effect.
Yes, go ahead.
Well, no, I have just a question that is directly tied to this, which is about the perceived risk. I'm Peter, I'm a journalist from the US, but I'm studying public policy here, so I've followed the debate on both sides of the Atlantic on this. But so I'm interested particularly in jury trials, because as we talked about earlier, juries definitely increase the perceived risk of the outcome and the variability perhaps of damages or the fact finding. They also make it more expensive. So I'm curious on your thoughts on how the 2013 reform changed the situation here. And also in Ireland, I know that they're considering removing juries as part of the anti-slap draft there. And I'm curious whether that's, because on one hand, juries seem to match the sort of public reputation measurement fairly well, but maybe they are sort of a procedural barrier and an access problem.
So
no juries, you just don't get juries now hearing libel cases here. That has made changes to the procedure, so there are more issues that now can be dealt with as a preliminary matter. There have been cases where people have said this should go to a jury, because in one case they said, judges are too biased or too woke or whatever to hear this kind of claim, and it should go to it. Juries are the proper arbiter. So you sometimes hear those sorts of claims. I've also heard criticisms to say some of the defamation claims, you've got the judges typically are people of a certain profile, age, class. and are they best placed to judge some of these questions? So, but I think they got rid of juries just because they were seen as an expense, and it seemed to push it.
It was the journalists' side. I mean, it was the journalists' side of the libel reform campaign that wanted to get rid of jury trial. They saw it as just adding cost, complexity, and uncertainty, and therefore making things worse for journalists. So that definitely came from that
And
side.
Gavin and Jake, was it more about dollars, or was it more about, I mean, I'm just thinking like connecting the dots with Sullivan. I mean, one of the big concerns that brought about the Sullivan standard in the US is that Southern juries at the time, I mean, it was sort of, the case was steeped in the civil rights movement, and the notion was Southern juries were going to side with white anti-segregationist public officials in the US and impose these staggering damages to punish the sort of northern newspapers like the New York Times. So the jury concern was a different kind of jury concern. It was baking in a constitutional check, a constitutional free speech check. But it sounds like you're saying that it was more about removing a significant expense in the space.
That's pretty much, yeah.
Expense and something that was seen as adding delay, because matters couldn't be resolved at a preliminary stage because they had to be decided by the jury instead.
So that this talking about the preliminary stage also brings us back to the way in which basically there's been an attempt to remove the real risk, the problems of slap suits, and that is largely by introducing a new preliminary stage. For example, the draft legislation, model legislation that was published in the UK by a range of press organisations and sort of free speech organisations suggested that there should be a preliminary stage in which the claimant, so again, thinking about as a well-heeled claimant, would establish that the claim is likely to prevail at trial, and that the harm suffered by the claimant as a result of the expression is sufficiently weighty to outweigh the interest in trying to suppress actions which are actually trying to undermine free speech. And in the various models of this in different parts of the world, but I'd be just interested in panelists' views as to whether this really helps. And perhaps, Sajjad, you might like to comment on this, whether you think these kind of initiatives, putting up a preliminary hurdle effectively for claimants in suits that are considered to be abusive process, are actually going to help or not.
I definitely have a view on this, and I think this is a problem that we can deal with in a procedural way, because fundamentally these issues are issues of balancing rights meaningfully are too big to be done except by courts in particular cases. But sets of procedural guidelines, especially, for example, the UK model anti-slap suggestion, I'd call it that, it does set out really, pertinent and real issues under what the definition of abusive suits. Similarly, the directive that was floated in the EU, the initial one of 2022, definitely did target an initial sort of strikeout mechanism as being a first step. My question would be rather, there already exist procedural rules in most jurisdictions for this. So what is special here? And the difficulty becomes the fact that you would essentially be conducting some kind of factual decision making, some kind of mini trial at the outset, which already prejudices rights of plaintiffs, for example. So it does get vexed, but again, procedural questions have procedural answers. So if you find something to be prima facie abusive or something, you can, perhaps require a deposit upfront of costs. There are answers within these models themselves. They're well thought out.
Thank you. I saw several people writing things down. Is there somebody you'd like to respond to that? Yes, Gavin.
Well, I've been looking through the draft model legislation, and the key difference is at the moment anyone can, the defendant can apply to strike out the case early on, but in this case it says the judge must strike it out unless unless the claimant can surmount those quite high hurdles, so that they show that there is a likelihood that they will prevail at trial instead of just a real possibility, which is a lot less. So they have shown that I assume more likely than not to win. And also that the harm suffered by them outweighs the public interest in dismissing the case early. I think, to me, the key question is what. So there's two elements then that make that bring in that duty to dismiss. One is if it is a suit against public participation, and that really, as defined in legislation, is very broad. It's just a public interest case. In other words, as Reynolds would have it. And the other one is abusive, is that it's abusive, and those are defined very widely as well. So to me, I mean, I'd want to look at them closely, and it'd be really interesting subject to compare it to the EU directive. But I think the judge would line how that was construed by, because it seems to me the essence of it is abusive rather than the public interest, which is very broadly defined. That would catch a lot of cases, if not perhaps most of them. But whether it's abusive, which actually really it should be defined as ALPS rather than SLAPS. It's abusive lawsuits against rather than, and they say actually strategic doesn't really work. It's just become a label. What would the judges in practice find to be an abusive? And I can see there's to be an abusive practice of litigation. I can see there's ones where they're threatening disproportionate damages, or they're threatening disproportionate discovery, or imposing, those kind of clear bullying by lawyers against kind of people who are impecunious, small NGOs or independent journalists or citizen journalists even. But outside the clear cases, I wonder. I'd sense the judges might be quite reluctant, because they're generally quite reluctant to strike out, because they always think, well, we need to hear the full facts, we haven't heard full argument. So I wonder what would happen to this in the hands, perhaps particularly of English judges.
Absolutely. No, I think that's right. The risk of having like a mini trial is one that they want to avoid. The other thing I think, just to add to that as well, is that judges here don't like the idea of someone that's suffered a loss or injury to reputation unfairly going without a remedy. Mm-hmm. So you see that with the public interest defence. There's a caution there, because they realise if the defence succeeds, they go home with nothing. They'd be worried about that here as well. So it might lead to a narrow definition, and I think they might be reluctant to characterise a lawsuit as being a slap. As being
abusive.
Yeah.
I suppose one of the things I find difficult about it is being able to decide on the papers effectively, without a trial, with how likely it is that the suit is going to succeed. Because normally you've got a claim which might seem quite straightforward, but you've got a defence, and the defence is often going to be highly contextual and evidence-based. And we spent a little time earlier talking about whether we thought, Dominion voting systems would prevail, and particularly the difficulties of establishing the lines of authority within Fox News. Now, these are the kind of things that are going to arise in quite a lot of defamation claims. So I just wonder how practical it is to raise the standard of likelihood of success and then be able to actually effectively deal with it without some kind of trial process.
It depends on a set of very complex facts. I mean, I think that's why English courts have held on to the no interim injunctions in libel cases, whereas you can get interim injunctions in privacy cases. And that's because it's more of a normative assessment. Is the kind of public interest claimed something that can outweigh the privacy damage by the revelation that's complained of? But in defamation cases, it so often involves a complicated factual matrix, and the judges, I think they would just think, how can we decide whether this is more likely than not to prevail at final trial? We're just not in a position to do that. And therefore, I think they'd be reluctant. I mean, that should mean they would strike it out, but I think they'd find a way of not.
But you'd also have an Article 8 issue, because where reputation's protected by Article 8, you might say by striking out too easily, is that not protected? So there's a risk there as well.
Exactly. Yeah. So that's been a really interesting conversation. I'm going to give each of our panelists sort of 30 seconds, and I'd like them to look at the questions online and potentially consider whether they would like to respond to them. So there's the question about sort of comparing the US and the UK and how the calculus works, particularly looking at plaintiffs not recovering costs and the ordinary approach in the US. And we've talked about the no longer having jury trials since 2013. And perhaps just add into that mix that under this model law that was proposed for the UK, costs is a very core part of dealing with slaps, and it's something that Satyajit referred to earlier. And then there are two more comments from Owen Adele about juries and slaps. So shall we start with you, Ronel? Then we'll go, no, let's go backwards. We'll start with Satyajit, then go to Ronel, then James, then Jake, and then Gavin. 30 seconds, please. Satyajit.
No, my takeaway from this, of course, I was fascinated by the Sullivan discussion, and fundamentally, just returning to that, I would say that I'm deeply, deeply fearful and distrustful of anything that lowers the standard of a Sullivan type defense. Just fundamentally, I think it's too dangerous to be left in the hands of in unstable democracies, certainly.
Thank you. Ronelle.
I actually just wanted to make an umbrella comment that was spurred by some of the things that Jake and Gavin were saying, and that I thought were so interesting. It really, this conversation has really gelled for me and really highlighted for me how some of what's happening isn't just, it's not just a gap between approaches, right? Or a gap between standards. It's also just a gap between sort of underlying cultural and jurisprudential values. And it occurs to me that the same sort of very adamant American exceptionalism, pro-free speech values that drove the Sullivan standard are also what animate and really bring to life our anti-SLAPP statutes from state to state. So we would not have, in the ordinary instance, the kind of concern that Jake was talking about of a judge really having significant anxiety about a reputational harm going unremedied at that front end stage, because the forefront concern is about the public participation, right? The free speech value of the speaker who is being targeted in that context. And so part of what we're thinking about is what's sort of what the competing values are and how to actually foreground them in a way that sort of respects human rights across the board and sees those competing values. But a part of what we're talking about is a really practical question about sort of how America is moving in one direction and how the UK is moving in another, but how they're motivated by their undercurrents of sort of core values that I think complexifies our ability to compare and contrast and to make the apples to oranges comparisons. I'm really interested in continuing the conversation with both of them, with all of you.
I was threatened to say something about disinformation generally, and I'll do it in the 24 quick. No, and that is that, speaking of cultural differences, we have this case, Alvarez, in which all 9 justices seem to say that if it's a matter of public concern, there cannot be punishment for lies. Outside of defamation or some other narrow exceptions to the First Amendment, but generally that can be, and for what it's worth, I think that's right, is in terms of, because of cultural differences about how our judges are selected and our prosecutors for public discourse, but not outside of public discourse, which I'll leave it at that.
Great, thanks, Jim. Jake.
Just following one of the questions, legal costs are part of the problem as well. Often if you lose a case, the legal costs can be bigger than the damages that get paid. So it can be very significant. The trouble is there's no easy solution. You can't do justice on the cheap, and if you need some system as well where people can have access to justice and can bring a claim, and that's one of the problems I think they're trying to grapple with.
I mean, just an illustration that Naomi Campbell, in a famous privacy case in the UK, won £15,000 of damages, but the costs were over £1 million, which the newspaper had to pay. The other point was just, yes, I mean, Jake was quite right. So both in privacy law and in defamation law, in the UK, you have constitutional right versus constitutional right that start on an equal status. In other words, Article 8 protecting reputation and privacy, and Article 10 protecting freedom of expression. In the US, you have constitutional right versus tort, which is why the constitutional right, it's David and Goliath. But the final point, which we'll discuss when we meet again in London, Ronelle, with Jake in person, is why does the legacy media that do fact checking, why do they need Sullivan? Because Reynolds should protect them and would protect them. So Reynolds is there to protect people who do a reasonable job in fact checking. That's it, basically, just some due diligence. And the Washington Post, the New York Times would be fine under Reynolds. So why do they need Sullivan? That's what we can talk about more next time.
Great, well, great way to end. Thank you all for a really lively conversation and debate about really pressing issues. I'm sorry that Satyajit and Ronelle are not going to be able to join us for a reception here, but it's been great to have you online. Thanks very much. Thanks to all of our participants who joined